Mr Speaker, I'm happy to follow on from the Minister and to say that the Labor Party will be supporting the Insolvency Practitioners Bill. In fact, I welcome the first reading of the bill. I was involved in the Insolvency Law Review at various stages of its process or progress. I think it began in 1999 and there were a number of different aspects to it as it traversed its way through the different processes involving a number of discussion documents. The initial discussion document in 2004 and then a subsequent one in 2006. On both of those, we actually did seek to address the issue of insolvency practitioners, and it was something that I personally wanted to have addressed. I can't say that I found particular support for the proposition from certain officials within the Ministry of Economic Development, but I did think that it was important, and I think what was really pushing back from the officials was the fact that there was such a small number of people involved in this profession that it did seem to be potentially a sledgehammer to, crack a nut, and I had some sympathy with that point of view, but I felt that it was important that we try to consult with those that were interested in insolvency law reform generally around this issue of whether we should have some sort of regulatory regime around quality control, as it were, for insolvency practitioners. The two discussion documents that actually raised this as an issue failed to produce a consensus, and that left me somewhat red-faced because, of course, the officials said, there you go, we were right and you were wrong, which, happened from time to time, as it does happen to any minister, I guess. But I still was very keen to see something tried, and we have the same issue around auditors, and again it's the numbers and the coverage and our relationship with other jurisdictions. It also is about our best practice and where we stand internationally, and where we might look with IOSCO principles, for example, with respect to these insolvency practitioners. So the negative licensing option, which actually hadn't been promoted in either of the discussion documents, was my last-ditch attempt to get some traction on the issue, and this was the one that we went out and did a very targeted consultation on. So this didn't go out for another discussion document. The consultation paper was sent to the specialist insolvency practitioner stakeholder bodies, and that was Insol New Zealand and the Joint Insolvency Committee, which involved representatives from the New Zealand Law Society and the New Zealand Institute of Chartered Accountants, and that was back in June 2008. And of course we were coming up against a general election at that stage, and so it was a relatively tough order to put to people in the lead up to a general election. But that agreement was reached, and I think that what really sold this particular model, the one that the government's now adopting by way of the legislation, was that it was a cost-effective form of regulation. So it wasn't going to break the bank, as it were. It wasn't going to impose unnecessary compliance costs on a very, very small sector. But it did recognise that there were a small number of people out there who essentially were causing a major problem, and the well-respected insolvency practitioners who we do have in this country were the first ones to be telling us that they existed and that there was sufficient concern to do something. It just really wasn't important. It wasn't sufficient to go that step further and bring in a positive licensing regime, but the negative licensing regime enabled action to be taken where action needed to be taken. And so, as I say, I really think the number of insolvency practitioners drove what I saw as a pragmatic response to the issue. They say that there's around 50 involved in full-time insolvency practice, and around 50 others who take referrals from time to time. So we are not talking about a huge amount of people, and I also want to give some public reassurance that this is not an indication of any great crisis in the sector, or that we think that the vast majority of insolvency practitioners have got issues. It's an absolute minority, but because we are dealing with people who have great responsibility at a time which is very distressing for shareholders, for creditors, for company management often, all of those different individuals who have concerns around the insolvency of a company in a voluntary administration, in a liquidation or in receivership, we have, I believe, an absolute obligation to make sure that we have the power to take action should that action be required to be taken. Mr Speaker, I took the opportunity of the introduction of the bill to actually grab a copy of the original Cabinet paper that I took through, which of course the Ministry of Economic Development helpfully put on their website on a regular basis. Now of course that's enabled me to have a look at the regulatory impact statement and refresh my memory around that. And I know that I have said this all this year, but I'm just not going to miss any opportunity to say this. It is a huge mistake to take the regulatory impact statement out of the bills. It really is much better to have the regulatory impact statement printed with the bills, because if you don't, then you have to go and print them out separately, and actually they contain the information we need to debate these issues in the House. So I've made this point to the Minister for Regulatory Reform, and I know that he has an issue with this, and the issue is that the regulatory impact statement is part of the Cabinet paper, and by including it in the bill, it may not in fact reflect the changes that have been made at the Cabinet. Well, I think that we could get some tweaking happening here. I think there's probably a germ of an idea where we could get that resolved. But anyway, I want to say that this regulatory impact statement, which I can take some credit for since I was the Minister who signed it off, is an excellent regulatory impact statement, and I think that everyone would be proud to have a regulatory impact statement of this nature. And the reason is that it states the problem, and it actually talks about the status quo and the problem, and it talks about the size of the industry, it talks about what the objectives are, it talks about what the alternative options are, and that was what was completely missing from the bill that we dealt with before. There were no other options included in that paper because the government had actually gone straight to the decision without setting out the options. But in this paper it sets out the first option, voluntary accreditation; the second option, mandatory licensing; the third option, competitive licensing; and then finally the option of negative licensing. And I think that is absolutely the way that all regulatory impact statements should proceed. You've got to state the problem. You've then got to set out what the different options are for addressing that problem, and you have to address the status quo. You do have to ask yourself what the cost-benefit analysis is, what the risk and opportunities are with respect to the different options that exist, and then you come up with the recommended option and you justify it in the regulatory impact statement. And that's why this particular bill is one that I fully support. It will make a difference, and I just want to make this point, that it isn't just in the instance of a shareholder-friendly appointee, as the Minister used that as an example, and it's a very good example of what can go wrong. But I also want to put it to people that there has to be money left in the company to pay the liquidator's fees. And if the liquidator thinks that chasing some money which doesn't have a certain outcome may not leave enough for the fees to be paid, then that may drive a totally inappropriate outcome for the individuals who are relying on the receiver or the liquidator to do the best for the interests of the creditors and the shareholders. So I do think that this is something that we will enjoy looking at the Select Committee. I'm very confident that we will be able to report back a bill in relatively short order that will gain the full support of the House.
Katrina Shank.